Good day to Sabat and my dear viewers. Welcome to my group assignment presentation video. First and foremost, I would like to introduce myself here. Hi, I'm THINESWARI, daughter of GUNALAN from section 2. Here my group members.
Hi, I'm BINTI FAZLI from section 2.
Hi, I am FARAHIN from section 2.
That's all about my group members. So we're moving into the first part, which is the introduction of employment law. Employment law deals with the relationship between employers and their employees. Following that, employment law includes status, workplace, contract or policies, and common law like court case. Then there are also law that set out rules for health and safety in the workplace. We're moving into the second part, which is the question. Here got three questions. We choose the question 1 and question 3, which is the question 1 is, Ali and a group of other workers intend to set up trade union in their workplace. However, one of the provisions in a contract of employment stated that any employees prohibited from establishing trade unions at their place of work or participating in any existing trade union. Can the provision be included in the context of employment? That is the question. We're moving into the answer. The first paragraph, which is the issue, where the issue from this case that I found is one of the provision is a context of employment status that any employees is prohibited from establishing trade union at their place of work or participating in any existing trade union. The issues that can be included in the context of employment. We're moving into the next slide, which is the opinion. In my opinion, the clause cannot be included in the context of employment. It is because certain groups of government servants are not allowed to join unions at all. These are employers in the policy creation service, the government focus, and those of confidential or security work. The right these are workers are restricted in the interest of security and safety of the current. Then the employees in the professional or managerial group in the public sector, unless they are an exitum from the chief security to the government. Lastly, category of employees, those membership is not the same category as themselves. Then these groups are managers, executive, and staff in the confidential or security person. We moving into the next slide. I will pass to my group member to explain.
So we move for paragraph 3, which is law. So to support my opinion, workers in Malaysia have the right to form and join trade union. Then this is known as freedom as association, and the right is protected in the Industrial Relations Act stated in Section 5. The Industrial Relations Act states that no employer shall prevent a worker from joining a union by putting a condition in his contract of employment. Following by that, the statement of Industrial Relations Act is no employer shall refuse to employ a worker on the grounds he is a trade union member or officer. In addition, no employer shall discriminate against a worker, like an example in terms of promotion on the grounds he is a trade union member or officer. And no worker shall be threatened with dismissal or dismissed if he proposes to join a trade union or he is participates in union activities. So we move for next slide.
Next, for the application, the provision cannot be included in the contract of employment. No employer or trade union of employer and no person acting on behalf of an employer shall impose any condition in a contract of employment seeking to restrain the right of a person who is a party in the contract to join a trade union or to continue their membership in a trade union. Every worker has the right to join and form a trade union. employees need to have a sense of job security and want to be sure that management will not make unfair and arbitrary decisions about their employment. They look for unions to ensure that their jobs are duly protected against layoff, recall, and promotion. For the next slide, I will pass to Farahin.
So as conclusion, we can conclude that the involvement of employee in the trade union depends on the employee himself in meeting his wants and needs in the job. In Section 7 of the Industrial Relations Act, workers also may not be forced to join a union. Any complaint by a worker that his rights under his section of the Act that have been violated can be reported to the Department of Industrial Relations.
Thank you, Farahin. So we're moving into the second section, which is the third question. The question is, Abu works as a mechanic with a basic salary of RM 5,000 a month at SW workshop. Recently, the management announced the insurance coverage that will be provided to all employers. Those categories are listed in the first schedule. Abu has informed that he has not eligible for the same cents under first schedule. The employee's basic salary must not be more than 2,000 per month. Express your view of the matter. That is the question. So we're moving into the answer. I would like to brief about the case one, which is the issues. Whether Habu is an employee under the first schedule since his salary is more than 2,000 per month. The issue that I found in this case is that the management announced the insurance coverage that will be given to the employees. Those categories are listed in the first schedule. Following that, Abu has informed that he has not eligible for the same cents under first schedule. The employee's basic salary cannot be more than 2,000 per month. So we're moving into the second part, which is the opinion. In my opinion, Abu is an employee under the first schedule despite his salary being more than RM 2,000 per month. Talking about first schedule, it is any person irrespective of its option, those if enter into a contract of service with an employer under which such person's wages do not exceed to 2,000 ringgit a month. Then any persons who inspirations of the amount of wages he earned in a month has entered into a contract service with an employer in pursuance. So that's all about the second part. We're moving into the third part. I will pass to my group member to explain that.
Following that, for the law, he engaged in the operation or maintenance of any mechanically propelled vehicle operated for the transport of passengers or goods or for reward for commercial purpose. Then he supervises or oversees other employees engaged in manual labor employed by the same employer in and throughout the performance of their work. Moreover, he is engaged in any capacity in any vessel registered in Malaysia and who is not an officer certificate under the Merchant Shipping Acts of the United Kingdom as amended from time to time. Then it is also not the holder of a local certificate as defined in Part 4 of the Merchant Shipping Ordinance in 1952 or has not entered into agreement under Part 3 of the Merchant Shipping Ordinance in 1952 or he is engaged as domestic servant. Next, for the next slide. For the application, Abu is still a worker because he works at SW Workshop as a mechanic. He is eligible to receive the insurance coverage that will be provided to all employees whose categories are listed in the first schedule, despite his salary being RM 5,000 per month. For the next slide, I will pass to my group member.
So we move for the last chapter is conclusion. So in case 3, we can conclude that under paragraph 1 of the first schedule of Employment Act, any person, irrespective of his occupation, who is entered a contract of service with an employer under which such person's wages do not exceed 2,000 a month is protected by the Employment Act. So Abu is a constructional worker as a mechanic in repair maintenance who deserve insurance coverage even his salary is about 5,000 a month. So this is all from question number 3.
Well, that's all from us. Thanks for participating with us. Thanks for view this video. Thank you, sir. And stay safe. Have a nice day. Signing off by Tinu,
Alia,
And Farah.
bye.
thank you.
Thank you.